in January, several weeks later, bringing it forward to the police. Perhaps a different analysis would apply, but that's not what we have here. We have an original arrest on this exact vehicle from December 22nd in the Court of Common Pleas that was charged as a vandalism case. They could have pursued a misdemeanor criminal damaging at the same time, perhaps. I'm not sure why that didn't happen, but what we do know is that as soon as that is dismissed on December 31st, I'm sorry, it was filed December 22nd, ignored December 30th, refiled on December 31st, and dismissed on January 5th. Those same facts are then filed in municipal court on January 16th. That's what I'm trying to explain, I guess, in terms of this all being related to the same case. The facts were known to the state. So in that situation, the question is, do we start the speedy trial clock on January 16th or December 22nd? And I think the answer is still December 22nd.
Thank you.
And on that note, I'll just rest on my reply brief because I know that I responded to Baker, I hope pretty thoroughly in reply, but I just wanted to emphasize those couple of details. So if there's no further questions, I'd ask that this court reverse.
Any questions?
Thank you.
Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely opinion. We are going to take a brief recess for the second panel to come to the courtroom, and we'll be adjourned just for a few minutes.
All rise. The Court of Appeals for the 12th District of Ohio is now in recess.
Yeah. morning. So we're here on the third and last case, which is In Re MD, cases number C220052, 53, 54, 55, and 56. If council can please identify yourself and your readiness to proceed.
Josh Thompson on behalf of MD, ready to proceed, Your Honor?
Thank you.
Good morning, Your Honor. Alex Hale on behalf of the state.
Thank you. Attorney Thompson, whenever you're ready.
May it please the court, counsel, I'd like to reserve 3 minutes for rebuttal. I believe we can all agree that at approximately 1 hour, 29 minutes, and 56 seconds into the video that includes MD's interrogation, he asks, "Can I have a lawyer?" While trial counsel filed a motion to suppress, that specific fact was not raised at the trial level or in our original appellate brief. Now, regarding our first assignment of error, the state essentially re-raises waiver as an issue. Now, this court well knows, however, that it can, under Criminal Rule 52B, notice plain errors or defects affecting substantial rights even when they are not brought to the attention of the court by counsel.
And that requires us to allow for briefing, is that correct?
Correct, which we did here.
Which has been done.
Yes. Undoubtedly, the rights of due process, counsel, and self-incrimination are substantial rights. And given the significant reliance on MD's own statements at trial, this situation is the exceptional circumstance that necessitates noticing the plain error to prevent a manifest miscarriage of justice. Moreover, the motion to suppress filed by trial counsel is not so limited as the state argues. The motion does ask for an order suppressing any and all of MD's statements. It raises the 5th, 6th, and 14th Amendments, as well as Article 1, Section 10 of the Ohio Constitution. It also raises the totality of the circumstances and the differences between adults and children under interrogation. And it also mentions that the totality of the circumstances includes the age, mentality, and prior criminal experience of the accused. Now, regarding MD's intelligence, we do know that the juvenile court's bind-over decision retaining jurisdiction included a check in the box that he had a mental illness or is a mentally retarded person. It also included a check in the box that he was not emotionally, physically, or psychologically mature enough for the transfer. Finally, during disposition, when trial counsel raised MD's mental health and his individual education plan, his statements were not challenged by the state. So while MD's request for counsel, his question about whether his father had been called, and his level of intelligence were not raised with great specificity in the motion or in the original briefs, suppression was raised generally, and the potential issues were now briefed before this court.
One of the arguments by the state is that that even if counsel was requested, that it wasn't understood at the time.
Correct. There's two issues there. One is, does it matter whether it was heard? There was a case in the 2nd District. It was fairly 2019, I believe, if I could, getting ahead of myself in my notes. State versus Moore, 2019, Ohio 648. In that case, at least to the trial court, it was irrelevant whether the request for counsel was heard because it was captured on video. The officer said he didn't hear it, but it was on video, and that portion of the defendant's statements were suppressed. Furthermore, here, one of the more obvious things is we know it got recorded, the request.
I mean, is it that it didn't matter, or was it that the court made a finding of fact in that case as to whether, whether it sufficed?
Yes, that it credited the recording over the officer's testimony that he didn't hear it.
That's what it sounds like.
Well, let me ask you, Mr. Thompson, I know that before the trial began, the judge said, "Are there any motions?" And defense counsel said, "Yes, I have a motion for separation." And that was it. It was granted, and there's no mention to the judge that there was a motion to suppress filed. And I guess in your original brief, you relied a lot on Rule 22D. So what are you suggesting to us, that every time a motion to suppress is filed in the juvenile court and not heard by the court or not brought to the court's attention by trial counsel, that is plain error?
It is an obvious error. We still have to show that
Okay.
the outcome would be
Okay.
different.
So, all right, so the judge has to pore over each of the or thousands of cases they have over there and determine whether counsel has advised them of motions that have been filed but have not been heard?
Well, if this was adult court and there was a jury demand and it wasn't waived, and the case proceeded to a bench trial, that would get reversed.
Well, you automatically get it, well, depending on which court you're in, so, okay, I understand what you're saying.
So I think if it got to an appeal like we are now, and like here, it wasn't re-raised or readdressed, then we would have to show that the outcome of the trial, one, that we would succeed on the motion, and two, that that the outcome of the trial would be different.
Okay.
Can you
And
discuss, I'm sorry, I
No,
didn't
no,
mean to
go
interrupt.
ahead.
Can you discuss that portion, please? Based on the testimony and, the fact that before MD requested an attorney, he did say that he had made a call from a particular number. Could you address whether there's a reasonable probability that the outcome would have been different, and why?
Well, that specific statement only refers to the night that he was arrested. So the most problematic night is obviously the last night he was arrested on scene. Regarding the first charge with Mr. Teeter, there was no admission prior to the request for counsel regarding that night. So Mr. Teeter could not identify him either. There is essentially no evidence without his admission on that case. On the second case, I forget the gentleman's name, but he said MD looks a lot like, or something along the lines of, looks like the person that night, but never identifies MD as the person. MD denies, prior to requesting counsel, any involvement with any robberies. He simply admits, these other guys put the app on my phone and I called and ordered the food. But he also says, I was going home. That was my plan that night. I wasn't part of a robbery, but I did call and place this order. On that third case, the night he was arrested, I still maintain there are issues with whether a aggravated robbery even occurred. We've already addressed it, but I think there are significant issues with whether he actually had a gun and whether he actually got to the point of even approaching the car, because the officer testified he got out with a gun. And MD, his statement was that he saw a gun and he ran. He didn't stick around to find out who had a gun. He didn't admit that he saw uniforms or anything like that. So I think the first two cases are really obvious that they would have had a different outcome without his statement. In the third case, I think it's reasonably probable that all they really had was him running from a parking lot and they found a gun nearby, and that his phone ordered food. I mean, it's some evidence, but I don't know that it's beyond a reasonable doubt.
Let me just go through this with you, Mr. Thompson. From my point of view, looking at the motion to suppress, say it was in very general terms. and watched the video, watched it 3 times, and I could not hear your client say, may I have an attorney, or can I have an attorney? And I knew where it was. Had to go through it several times. So this is, I'm getting the question part. So if we're looking at this motion to suppress, there's all kinds of ways this could have ended up. Had the judge heard the motion to suppress, she could say, well, based on his age, lack of understanding, the way the rights were read to him, I'm suppressing everything. All right. Or she could have said, okay, well, it does sound like he's asking for an attorney. May I have an attorney, or can I have an attorney? So I'm going to suppress everything after that. So then you watch the videotape, and now, and I'm setting aside whether that was a sufficient request for counsel. Okay, just assume it was. And the next thing is the detectives are interviewing maybe a couple more questions, and they stand up to leave, and the one fellow, he said, well, will you stay? So, I mean, do you see what I'm saying? There's all kinds of ways this could come out. And he may have reinstituted the interrogation. So I guess, what are you asking us to do here?
Well, I think the result of a finding that plain error took place would not be outright dismissal of the case. I believe we'd send it back to address these issues. But I'm honestly guessing. I honestly hadn't thought in preparing today what the outcome would be. But there are a number of issues, and in terms of the waiver, this is why I also raised ineffective assistance on the new briefing, that if it is found that it was waived, the analysis is essentially the same for ineffective assistance. And
I want to piggyback on the question, okay, that you asked, Judge Winkler, because I'm still in my head thinking about this notion of whether it was audible and whether it was understood, okay, which seems to be a finding of fact. And I know that both parties briefed that determination on that finding of fact. But it appears to me that it's not properly before us because we shouldn't be making findings of fact.
right.
So it appears as if on remand that would be something for the trial court to determine, which had not been determined before it came to us, whether it was audible, whether it was understood, right?
Right.
And then provide both sides to argue those issues, which brings to a very interesting conclusion on Judge Winkler's question, because it's all intertwined as to how it'll all play out also. So with regard to the motion to suppress, there's more than one way that it might be suppressed, and certainly the juncture changes what happens. You understand what I'm saying?
I do.
This is a long.
There are a lot of
motion.
factors here.
But it's also very interestingly intertwined because of, when it comes to the waiver part of it with regard to that determination, which it, again, doesn't appear that would be properly determined with this court. So how would you play that out, that portion of it, with regard to the waiver part of it? Because again, that waiver
I
is
think
contingent
what I
on that
asked for
determination.
in the original briefing, when I missed that this request was made, is that we go back and we have the hearing, and we have findings. There was some support for the idea that if we lose the motion to suppress, there doesn't necessarily have to be a new trial. But I do think that this issue very much needs explored. I think the last time we had an oral argument, when I went back, and it's one of those things that once I heard it, I couldn't unhear it, the request for counsel. And it's not dispositive today, but I do think there are some evidence that it was heard in the body language of the detectives, and I think it's worth questioning them about it at a motion to suppress hearing. So I think the proper outcome here, if it's found that this was plain error and it was, the outcome of the trial would have been different, would be to explore this motion to suppress at the trial level.
I'd like to follow up. Do I have enough time?
I'll give you all the time you want.
Okay. I just want to follow up on Judge Bach's earlier question. And again, this sort of makes us look at this motion to suppress and say, okay, would I have granted it, would I have denied it, or where, if I would have granted it in part? And the question that keeps coming back into my mind is whether it's outcome determinative. And I'll push back a little bit on your answer, because I've read through the testimony several times, 3 times, the pizza delivery and the police, as well as your client's statement up to the point where counsel, I'm just going to say, was requested. And during that interview, after he signed the waiver of rights, it was mainly denials, but there was an admission that, yeah, he did make the call, and that was his phone number. So I'm getting to the point where whether this is outcome determinative or not. So they got the number. The Papa John's pizza delivery man said, yeah, that's him. He identified him in court. Yeah, he had a gun. Yes, and the phone, the number that was called is the same number that we had plastered up on the wall. So when it came in, we said, well, we're going to call the cops. All right, so, pardon me. And the next witness was Queen City pizza delivery man. He couldn't make an ID, kind of was just trying to get out of there. He thought maybe there was a gun. It looked like there was a gun on his window. All right, so then the officers testified that they came in, sat in the lot, turned on their blinkers, saw the guy coming around, your client coming around, hopped out of the car because it looked like he had a gun in his hand. They drew their weapons. They say there was a gun, chased him. He was in a dumpster. A dog came and found the gun, I think 30 feet from there. So I guess what I'm saying is that you're saying that's not sufficient because it seems like it's a perfect case. Pardon me, I'll try to get through without coughing. Like a perfect case for 404B evidence of plan, motive, intent. I mean, all these robberies, well, at least the 2, were exactly the same. So you're saying that it's not outcome determinative? You understand what I'm saying? All the cops had is witnesses. We got this phone number, okay, and then the testimony I've just related, and the similarity between those crimes and the similarity of what happened on the night he was arrested. You're saying that's insufficient to maintain those convictions?
Yes, and I understand that there is sort of a gradient here. The one witness who just couldn't identify anyone is by far the weakest case. And then the little bit stronger case is, well, it looks just like the guy that was in front of me. And then the strongest case is, well, we found him on scene. But all of these cases were heard with admissions. And if all of his admissions end up being kept out, because there's a possibility the entirety of the statement is kept out, I do think that the outcome of the trial, there's a reasonable possibility it would have been different.
Okay.
So unless there's any other questions from the panel,
Thank you.
I'll reserve you 3 minutes.
Thank you, Your Honor.
Good morning.
Morning, Your
Attorney
Honors.
Hadlin. Can we, is it okay if I deviate you a bit, all right?
It
Can we
would
start
probably
off
help.
where Judge Winkler ended up, which was the outcome determinative portion of it?
Sure, Judge. I think, I'm not trying to dodge, I'm just kind of setting the scene for how I'm thinking about this. So much of this case now has been sort of thrown into like the hypothetical. So as you pointed out before, whether or not it was heard as a finding of fact. There are so many findings of fact that we don't have in this case that it's hard to, I just want that caveat out there, that if I'm not
And the reason
committing to anything, but
No, I hear you. The reason I want to start there is because if it doesn't change the outcome,
Sure.
then the rest of it
Then
is inconsequential.
Right. I think
I
that,
think we can all agree on that.
Sure.
Okay?
Right.
So
Doesn't matter.
So that's why I figured, let's start there before we go back into the, fact portion of it.
right. I think as Mr. Thompson was up here also, I made a note before Judge Winkler said it about 404B evidence. This is, and again, it wasn't addressed below because we had those admissions that were in, and they weren't challenged at any point until we were at Finneytown Middle School, or whatever. So I think, assuming that, on this record, I'm going to have a hard time answering the question, I guess, Judge. They could be or they couldn't be. I'm not sure.
Okay. Because ultimately what we have is a witness who says he looks like. We
Right,
have
so-
The whole thing with the dumpster and the firearm, right?
Oh, on the last one, yeah, right. So the last one, I don't think, I don't think any, if the motion to suppress was granted, even in toto, I still think there's enough evidence in this record to sustain the adjudication. As Mr. Thompson said, I do think they kind of go down then from there on this record. The second and first in time, I believe, was the witness who said, yeah, he looks like him. But again, you have the same phone number. That was, to your point, Judge Winkler, that is common in all three of these. It's the reason this even came to a conclusion is this phone number. So and it's,
And I always, because the outcome determinative language varies on what we're looking at, right? So when we're looking at plain error, it's whether there exists a reasonable probability. Am I correct on that?
I believe, yes,
Okay.
Judge.
So I think that's what it comes down to, whether it's a reasonable probability, not whether it would actually happen, but whether it's a reasonable probability.
Sure, and I think, still, the first one I think is not, I think the first, or the last in time, the one where he was arrested, I think is fine. I don't think it matters where, because when we're talking about a reasonable probability, are we granting the entire motion to suppress? Are we granting it, are we going back in time and editing the motion to suppress that was filed to include the request for counsel, and then stopping it at that point? That's why,
So let's start off with the whole, everything is suppressed.
then I think the first one is still fine. The second one,
Based
sorry.
on what evidence because,
The testimony that the trial court found, the fact that he approached what the police, a covert cover car the police put there to look like a pizza delivery car after a number had been called, called to order a pizza delivery that had robbed 2 prior drivers. They do this on purpose. He approaches the car with a firearm, police immediately is found in a dumpster. The firearm's found on his track. I think that is plainly sufficient.
the standard isn't whether it's sufficient, is whether there's a reasonable probability that the outcome would be different.
Oh, I'm talking in terms of evidence. So I'm saying sufficient evidence without the statement. Sorry. I think there's no, I don't think the outcome would be different without the statement in that case, to answer in those terms.
Okay.
Because I think the still admitted and accepted evidence is sufficient. That's what that's how I was phrasing that. And the other two, we have the number, and one, we have the guy saying it. Reasonable probability, yeah, maybe. On this record, I think it's, I mean, I guess I would, my caution with this is, I don't think the motion to suppress as it stands presently is likely to be granted. I don't think they would win that, because I don't think there's anything in it.
Right, but I wanted to go first with the outcome, because obviously.
Sure, but I think we
So
can't.
let me ask you a question now, and I'm going to go to this whole notion of the findings of fact with regard to whether it was audible, whether it was understood.
Yes,
Okay?
sure.
and I'm asking you a question that I don't know the answer to.
This is-
So, can we remand it just for that determination of fact? And then that determination of fact would govern whether there would be a hearing on the motion?
If the request was made, is that the fact you're talking about? So really the only, how will we get there? So this is what that doesn't make a lot of sense to me, Judge. This is a very
Because usually
odd
you have
posture.
the motion in order to make the determination of fact, right?
Correct.
But here, because the motion was never had,
Sure.
I'm wondering whether we can remand for the determination of fact, and for that then determine whether a motion proceeds and on what basis the
Right.
motion proceeds.
So the way that I have thought about this, and sort of the avenue in which to get it there, the only one that really makes sense to me is an ineffective assistance claim.
Problem is that that's so intertwined with the outcome determinative part of it.
No, well, it's the same, right. The outcome determinative isn't an assignment of error, though. That's just a test of the plain error and the ineffective assistance claim.
I don't think you can get to the ineffective first. I think you have to get, because the ineffective only flows if there was actual error.
I think error, I guess I would just disagree with, I think we have assignments of error all the time that are just ineffective assistance of counsel that don't have corollary plain error assignments. I think
That's not what we have here.
now no, it's not, but I think this court can pick which one they want. And my estimation is the plain error assignment, I think it's simpler to say trial counsel was ineffective for not asking that this motion be heard. They're probably ineffective for not including the statement in it, but I don't know that, again, with Xenia v. Wallace, we have the motion we have. We can't go back in time and rewrite the motion.
Well, how would he be ineffective if the fact that this lad may have asked for an attorney wasn't discovered until it ended up in the Court of Appeals?
Right, or if it was even, I mean, the procedural posture of this whole case is evidence of the fact that this isn't really a clear issue. I think that's a great question, Judge. I'm not sure. I don't know. There's a fairly significant record problem in this case that I'm not sure of an appropriate avenue to resolve.
That's the problem I see, is like maybe Judge Bach would, had she been presiding, would have granted the entire motion and suppressed it. Now, maybe Judge Zayas would have said, well, I'm going to allow in the portion before he asked for an attorney. And I might have said, it's all good, keep going, So that's the problem. We don't, we don't know what the outcome would be.
No, yeah, Judge, I don't know. The plain error assignment, I'm not sure of how that, I suppose the court could say plain error on as many as the court decided to, and then remand, I guess, for a hearing. I don't know. I mean, I've not seen a case like this. Obviously, the only case I found like this is the one that I cite for my waiver argument. And that, I still stand by that position, because I think, it's got to be incumbent on an attorney you got to prosecute your motions. That's not the court's job.
Yeah. But again, the problem is the outcome determinative part of it.
I understand what you're saying with that, but, that's why we have ineffective assistance claims, first of all. And second, I don't think the state objected when this court ordered rebriefing.
No, I didn't object to rebriefing. That's fine. I have no objection to the, is there,
Okay, I guess
Follow-up to
what I'm
that.
saying is if this child's trial attorney failed him by not bringing up the fact that he asked for an attorney let's just say that it was clear that he asked for an attorney, and he failed him by not raising that in a motion to suppress. I mean, are you saying that that whole issue is waived because the trial attorney failed him? I mean, isn't that the purpose of ineffective assistance claims?
Sure, and that's why, I believe that's why I said before that that is the avenue that I saw this, that was the only way I could work in my brain to get this case back.
Okay.
That's
I
the only one that
misunderstood.
makes sense to me.
Okay.
I don't, the whole plein air thing isn't really, I understand that you can observe it sua sponte. I still don't, we have to square the, right. I think it's a determination, if we could rewind the whole thing back, I think it's ineffective assistance should have been raised in the initial brief because he didn't prosecute his motion. I think that's the way you get there. I don't think it gets backdoored with this plain error thing and that it's the court's fault. I've certainly, as a trial litigator, never benefited from the court being wrong on not doing one of my motions. Never heard of that. I don't think that's the way it works.
Okay.
I could
I
be
misunderstood what you
ineffective
were
for
saying. I
that, I
understand.
think. I think that's the only way we could possibly get there. I still think that has to be squared with a waiver thing in some fashion. I mean, that doesn't go away, certainly because of this. And it's, right. The fact that we're here on a rebriefing because this defendant may or may not have said this is all complicating all of this also.
Actually, I think what's really complicating this is the fact that the defendant asked for an attorney and whether, the fact of whether that's audible and understood. I think
Sure, no,
that's what really
that is-
complicates it, because normally you would have a record in which the findings of facts have been determined.
Sure, and that's,
Here we have no record of the findings of fact being determined because of the
Yes.
procedural posture of the case before it came to the Court of Appeals.
correct.
So I think that's a novelty that's very unusual, because depending on, there's two junctures, right? So for one of those junctures, that's very important as to whether, unless it's determined on the outcome determinative and saying, well, there wouldn't have been a different result, then the rest of it is inconsequential.
Right, and that was the appropriate distinction, I believe, you made, Judge Zais, to the case Mr. Thompson cited. The court, I believe, in that said, oh, yeah, you did hear it, basically. We find on this record you did hear it. That's another problem. US v. Davis says that this is an objective standard. So it is, I think that is the controlling fact we have here, even though we don't have that fact in a record. That's what we need to know to talk about this in any real detail.
Exactly. That's why I'm wondering if, remanding for for that finding of fact.
Sure, and I'm right. I understand that. I just don't know. I don't know the avenue to, the plain air thing is still just kind of it's not really tracking with me.
Mm-hmm.
I think that ineffective assistance, had it been raised initially, made more sense to me. It's now raised now. I understand there was an order for rebriefing. I'm not debating that. But and then there's the Xenia v. Wallace problem also that, on this record, the motion we have doesn't include the so I don't think we can make much headway there either. So that's my best guess at how this could go if it goes that way. If there's going to be a remand, that's all I would have.
Let me ask you, Mr. Haviland, my understanding is the portion where this youngster may have requested counsel, that was actually played in court. Am I correct or incorrect in that?
I believe they played the whole statement.
And nobody said anything?
No. I mean,
Like the
right.
judge didn't say, wait a minute, I just
No.
heard him ask for an attorney?
No. We're here on it.
His attorney didn't say, wait a minute?
No.
Okay.
It's not in the motion, right. I mean, we're here because nobody heard this. So I don't,
Watching the video, though, what Chris had pointed out, I watched it multiple times, and mean, it does appear that the one detective, Detective Delk, did react. He didn't stop the interview, but it did appear that he reacted. Do you disagree with that?
I didn't see that, and again, I don't think I'd be very uncomfortable making that call here. Because I don't know. I don't know that that's what this court should do, Judge. I mean, that's, so I didn't see anything. I think, I can't remember the other detective's name. He was in the middle of saying something. Yes, thank you. Yeah, I mean, the flow of the interview to me, they were having a discussion. And it didn't, but, I could have missed that also. I don't know. There's a lot of things that obviously may or may not have been missed. But again, I think that I'm very weary of litigating a motion to suppress, especially one that wasn't even really filed below here for the first time. So I don't think we can do in terms of a remand. If it's going to be remanded, if waiver is not going to be heard because of I would assume the ineffective, perhaps the plain error, then I think, yes, a record of this would be required for this court to do anything else with it.
Thank you.
I mean, if there are any additional questions, I think I am happy to rely on the two briefs and whatever happened at the previous argument.
All right, thank you so much.
Thank you, Your Honors.
I think what we've learned today is that, frankly, MD was failed at every step of the process by trial counsel, by myself, to the court for not resolving the motion somehow. We all missed this request, but once you hear it, it's obvious. And I think the right thing to do for justice, to prevent a manifest miscarriage of justice, is to go back and figure this out. Whether these statements should have been suppressed, all of the potential issues that come up with potentially restarting, whether it was heard, everything that came up. And if the case is strong, and I don't think it is, then he'll be adjudicated again. But I don't think it is. I think there's a very reasonable probability that the outcome will be different in each and every one of these cases. So for those reasons, I'd ask that the court reverse and remand, and we go back to the motion to suppress stage. Thank you.
Thank you. Thank you both for your arguments this morning. I will take the matter under submission and issue a timely decision, and I wish you both a wonderful afternoon.